All right. Well, good morning, everyone. I want to welcome you to the Judiciary Non-Civil Committee meeting. We have several bills on the agenda today, and one of them is not on the agenda, but I'm adding it on Senate Bill 320 because it's late in session. We just kind of overlooked accidentally Senator Payne's bill. So what I'll do is I'll ask Senator Payne if he'd be willing to come forward at this time to give an overview of his legislation, and we'll also go ahead and get sign-up sheets out for Senator Payne's bill and the other two bills on the agenda. Evan, if you can help me with that. So, yeah, she's coming one more. All right, very good. All right, and for committee members, Hanif will be coming in with additional folders in a minute, so you can just flag her down when she comes in. So, all right, good morning, Senator Payne. Go ahead and present your bill.
Yes, sir. Thank you, Mr. Chairman. Thank you, committee. This is a real simple bill. It was brought to me by a district attorney who ran into an issue in the code of trying to prosecute a case. And right now, in the sex offender registry, they're required to register within 72 hours of their birthday annually, but those of most egregious sex offenders, those aggravated cases, are required. They are also required to do it on their half birthday every year, so essentially every 6 months. And because it was omitted from the code, it was not in the code, the penalty for those on their half birthday, right now all he can charge those sex offenders with is a misdemeanor. And so right now, to bring it back to the same as their birthdays, all this language does, and puts the penalty same as if they failed to register on their birthday.
All right, so just to make sure I'm clear on this, lines 14 to 16, that reflects that the punishment should be consistent with what is currently in code 42-114F, and lines 31 to 32 reflects back to that language in 42-112N. Is that right?
Yes, sir. It's not really a change in the law. It's just literally just to make sure that the law is.
Okay, and it looks like lines 21 to 22 or subsequent, that's just to clear up.
Yes, sir.
It's really just drafting to clear up. Okay. All right. Any questions from members of the committee? All right, seeing none, are there any further witnesses or any further discussion that any members of the committee think we ought to have on Senate Bill 320? Yeah, please. All right, what I'm going to do, Senator Payne, is if you don't mind, because this was an add-on to the agenda, and I apologize for my oversight in that, if you wouldn't mind just holding tight for us for just a minute.
Okay.
We want to just see if the Georgia Association of Criminal Defense Lawyers or the Prosecuting Attorneys Council have any comments that they want to give. And if they do, we might want to give you an opportunity for the last word. So I'll kind of leave it up to you. If you don't mind holding tight for us in here, that'd be good. For just a minute while they take a look at it. Would that be okay?
Chairman. Yes, that'd be absolutely fine. And
All
I'll
right.
just add to that, there was no opposition to it when we presented it to the Senate.
Okay, very good. And was there any sign up on that? No comment. All right, well, I'm sorry. We've just been told there's no comment from either of those organizations, so we can go ahead and take the bill up now. Recognize Vice Chairman Gravely. Motion do pass. Is there a second? Second. All right, all those in favor signify by saying aye. Aye. Any opposed? All right, very good. It's on to rules. Thank you
sir.
very much,
Appreciate it.
Senator. All right, at this point in time, I will turn things over to Vice Chairman Reeves so that I can present a substitute, and I want to get a copy of this to Mr. Lanier as well, so
This is a substitute to Senate Bill 28, right?
40.
40? Okay. All right, your mic should be on.
Well, thank you, Mr. Chairman. So, ladies and gentlemen of the committee, I present to you a substitute to Senate Bill 40. As you recall, Senate Bill 40 was the precursor. It was one of the options for what ultimately became inappropriate sexual contact with another person in a respective role. We had teacher, student, people like that. And ultimately, the legislation passed in a different bill number. And so, as we are late in session at this point, I'm bringing up an issue that has become, that has come to my attention due to COVID. So, the Regulated Industries Committee, I'm aware, has considered, is considering other matters right now, and this was an option to consider this through Judiciary Non-Civil. Yeah.
I don't think we have the bill.
What we have is an amendment, and so
So
We
this
don't have-
amendment should be considered a substitute, would just
Okay.
be treated as a substitute replacing Senate Bill 40.
okay,
AM 360809.
okay.
So it's totally replacing?
That's correct. So the issue is that the currently the Department of Revenue prohibits, the state law prohibits the sale of to-go mixed drinks, or what the code calls spirits. So drinks that are prepared at a restaurant, cocktails that are prepared and put in sealed bottles and sold to go, that's not legal to be done. But in some places in the state, it's being done illegally right now. And the real issue is if cities particularly are strictly enforcing those laws, then you might have one business where it's prohibited and a different business in an unincorporated area where it's allowed. And that's problematic, particularly for restaurants in the current COVID-19 world that we live in. So the proposed substitute here would allow sale of to-go mixed drinks only after September 1st of 2020, and it would sunset March 1st of 2021. It would just be a COVID Band-Aid for a short period of time. And all other provisions that are currently in place for the restaurant to sell drinks would still be in place here. So they must have a license, they must comply with all our requirements, they must comply in every other area. The policy view that I take in this is I'm aware of constituent issues in this area, and also I believe that this is no different than, because we have a sealed bottle here, no different than what we see from convenience stores and other sales from other locations. Based upon that, I'd be happy to answer any questions, would appreciate your favorable consideration.
Representative Kendrick?
Thank you, Mr. Chair. I'm really excited about this bill, not because I like drinking. But what is I'm trying to figure out why, or what is the current status of wine bottles you can take out, but you can't take out mixed liquor.
You're
Is that-
exactly right.
okay.
Wine and beer can be taken to get their provisions allowing that, but spirits, that's prohibited.
And so the sunset of March, I guess you answered that question, is only for COVID-19 purposes. And so if we wanted to extend it, we could.
That's right.
Yeah. Okay.
Mr. Chairman, explain, I see on lines 35 through 38, it looks like it leaves a home rule or local. Explain how 35 through 38 affects what you're doing here.
Yeah, so you must have a license in order to sell, in order to in order to fall here. And the point is, a restaurant would need to have a license to sell in the restaurant in order to be able to provide the to-go mixed drinks.
But but as far as the municipality and county, so the way that I read this, and I might read it wrong, is that whatever so does that have to strictly do with the licensing, or does it allow counties and municipalities to make a local decision on whether or not to allow this?
I'm sorry, good question. So there are local rules as to what days and times can be sold, and so the sales would have to comply with those local rules. And we're all familiar with the votes that take place to authorize, for example, Sunday.
Yeah. So if a city has not authorized Sunday sales, then a restaurant would not be allowed to do this on a Sunday.
That's exactly right. It is just as if the restaurant was selling with it for consumption on the premises. It's all the same rules apply.
Okay, does anybody have any other questions? Does anybody want to speak on the bill? Is anybody outside that you are aware of?
No.
Okay, any further discussion by the committee? All right, well, at this time, I will call for a motion. All right, Representative Gravely has made a motion due pass to AM 360809, which is going to be substituting in for Senate Bill 40. Is there a second? Okay, are there any amendments? Seeing none, is there any further discussion? All those in favor of the passage of the amendment to Senate Bill 40 state by saying aye. All opposed? Congratulations, Mr. Chairman. You took my seat, Bodie.
You need a copy of this? You have it? Okay. Do we need to talk? You want to do it now?
You mentioned a September 1 effective date. I don't see that in there. I just want to make sure that's correct.
Well, thank you for that. I thought it was in there, and I agree with you. I don't see it. I apologize. My understanding from Legislative Council. So, is there unanimous consent to take back up the Senate Bill 40, which was just before the committee? Is there any objection to taking back up Senate Bill 40?
Just a question. Does the chair have jurisdiction if it's in a rule?
So it's, yeah, we can.
No committee report yet.
There's no committee report in it. Thank you.
I learn something new every day.
I haven't signed it yet. So, all right, good question.
Check with the Senate on the constitutionality.
So,
That was good.
all right.
Good one yesterday.
So it's back before us at this time. I will just brief commentary here. You know, I'm interested in this being effective as soon as possible, but if the governor doesn't sign it before July 1st, it would become effective January 1st. So, what is the earliest available date for an effective date, Mr. Lanier? So, is there any objection to an amendment to Senate Bill 40 as amended here that would make the effective date upon signature by the governor? Is there any objection?
No.
All right, then committee will do that. All right, thank you very much. And just to just for the record here, so all those in favor of Senate Bill 40 as the substitute as amended here with an effective date upon signature by the governor, signify by saying aye. Aye. Any opposed? All right, thank you very much. Okay, our final bill on the agenda for today is Senate Bill 208, and we have the substitute that's before us. What I might ask the committee to do is for us to attempt to go section by section, and if there are any questions as we go, to identify those along the way and just have a conversation about it, if that would be acceptable. And I know that Ms. Doldy also said she'd be available because she's worked on this primarily if there are any specific questions as to the DUI code. But the important notes are, my understanding of this draft is, first of all, the indigent hardship applications, which there was a request for that to be codified with the specific cap rates for any interlock. That is now included, as well as a cap for the interlock. Maybe I'll just go through section by section, and you can stop me along the way if there's any questions. So the first few sections are concerning the limited driving permit and the ignition interlock driving permit. The 18 months at the top of page 4 is a change from existing policy, and this was discussed last time at the last committee meeting. I'm sorry, LC 392707S. So I'm on lines 102 to 105. Maybe what would be best is I would ask if, Hanifa, would you please ask Gactel and Pack to come in the room and to sit in the back of the room at microphones? Good morning. If you'd like to come on in, please, General, and just have a seat. Very good. All right. Well, thank you all for being here today. Can we get copies of Senate Bill 208 for General Bettis? Here. All right, want to make sure we all have the same sheet of music. So again, LC 392707S. This is the new substitute of Senate Bill 208. If we just look along together, sections 1 and 2, it's my recollection, are simply updating the code with respect to the IID limited driving permit. But the first substantive policy change that I see is line 102 with the 18 months instead of the 3-year suspension. General, do you agree with that? Yes. And I'll go, what's your microphone number so anyone watching online can hear you? What's the number? 16. Very good. All right. So does that look correct, the 18 months in place of the 3 years? Yes, sir. Okay. All right. Then if we move on to the middle of page 5, this concerns the IID license for the existing I'm sorry, let me back up. I believe what we're doing here is keeping the existing limited driving permit as an available option so that you are not required to use an IID permit if you get a hardship waiver from the court. All right. Also for DUI drugs, because the House Bill 799 language is included in here. Representative Setzler.
Hey, Mr. Chairman, I was unclear. Under what circumstances are we still keeping the limited driving permit? I wasn't clear on that, sure.
Yeah, the limited driving permit will still be available for a hardship waiver. So if a judge decides to issue the limited driving permit, it will be in the discretion of the judge to give it if the criteria for hardship are met. And we'll get to that, I believe, in the bill. And also, for DUI drug, there is not currently a limited driving permit, but there would be one available under this bill, but it would have the restrictions on where you can drive. Representative Kendrick.
Mr. Chair, this might be a drafting question, but we're still in section 2, right? I'm on line 123. It strikes out the language unless waived due to a financial hardship. So I don't see that language in any other part of section 2. So it's not possible for someone to get that fee waived due to financial hardship anymore.
It's my understanding that it is, and if it's all right, maybe we can just flag that, and we'll get Ms. Doldie on the phone and go through all of those later. But it was my understanding that had been addressed.
Okay, my second question is maybe a drafting proposal. So on that same line, 123, it has two restoration fees, one for $200 and one for $210. I'm assuming the $210 is the highest one because there would be an additional fee for mailing. So maybe the $210 and $200 switched on line 120. You see what I'm saying? On line 123. So the higher amount is when is mailed in. Is that?
I think for simplicity, why don't I put one number in there? Just
Yeah,
I'll do that too.
so what
simplicity gaps are.
So what we're doing is, if you look up to line 111, we're just restating existing law.
Okay.
And so what we've very deliberately done in this draft, we have not gone into other policy questions in other areas of the law. We're simply trying to add in certain objectives to the existing code. All right, so Section 3, again, is implementation concerning the suspension requirements. Section 4, if you look at lines 336 to 343, this is concerning the ignition interlock limited driving permit for these circumstances. So you see discharge, and this is what Representative McLaurin was working on, which we'll get to in a minute. And also suspension related to first conviction, which is existing. It's existing law, except that now an IID will be required for a first DUI suspension, for a first and 5 years DUI conviction, which thereby results in a suspension by operation of law. Then you see an order from court to allow for implementation of the IID through DDS in 372 to 378.
Mr. Chairman?
Yes.
And I don't want to throw you off your stride as we're looking through this. I know we were moving towards a first offense interlock across the board, is there another way to handle the issue of indigency than this continuing this temporary driving permit thing? I mean, from my vantage point, we want to apply law equally. If there's a public safety interest in people using an interlock device, why would a low-income person not also need an interlock device, even if we needed to provide some funding mechanism for the same? I mean, it would seem, we're tacking on fines on speeding tickets, which I'm publicly, very suspicious of. But I mean, I guess the question is, does this temporary driving permit or limited driving permit for DUI not create a circumstance where there's sort of two tiers of justice, and we're going to, in effect, have lots of folks with first offense DUIs still driving around without an interlock device? It just seems to be inconsistent.
Right. So I know that was an issue that was raised, I believe, by both PAC and by Ms. Travis as part of the debate that we had last time. But it's certainly a worthy discussion, because I take the gentleman's point very well. So let me begin first with General, and I'm sorry, is it Betts or Bettis? Bettis. All right, General Bettis in the back, who can maybe give us some help with that.
Well, that was our concern initially, is that it does create some disparity there between the middle class, upper class, and then those that are indigent. People who are able to pay, have an ignition interlock, and can drive anywhere they want to drive at that point. Because we've taken out the restrictions in this bill to work, school, and medical. And a person that is indigent will then get a permit, limited permit, and they can only drive to those limited locations, work, school, and medicals, which we normally title them. And so those that can pay more, and have higher restrictions on them, or more restrictions than indigent. And overall, if it could be, or we'd like it to be that way, the disparity is concerning.
Because, Mr. and I raised the question, Mr. Chairman, because there's it cuts in both directions. You have people with more income; they get to get the concierge DUI, they get to blow in their tube, and they get go where they want to, and low-income folks can't. And on the flip side, low-income folks are not held accountable to make sure that they're driving safely with an interlock device. They could be driving drunk to the place they need to go, or in the confines of their limited driving permit, because they're not having to blow into a tube. Furthermore, I'm not really sure anyone's watching where they go, so I think they are driving kind of around where they want to go. It just seems to be the very strength of your bill, which I think is very strong and appropriate. Is it appropriate to set a higher fee and have, I don't mind that middle-class drunks who've been caught for DUI pay a higher fee to subsidize the economy of this process, so that part of their fee goes to fund indigent DUI offenders. I don't have an issue with that. Perhaps that's an easier way to do this. And I know we're getting late in session, but from my vantage point, a clean break that says everybody who's a first offense DUI offender is going to have an interlock device, and we just raise the fees on people with more financial means, so that the whole economy of the system can be funded, and lower income folks can be funded through higher income people. That to me seems more consistent. I'm just very nervous about this limited driving permit thing, particularly from a starting point where that's what we do now. So we're trying to change behaviors, and conventionality, I think, will tend judges who aren't necessarily friendly to this idea. It creates incentives for them to kind of avoid the interlock regime we're putting in place.
Ms. Travis, do you want to speak for Gactel, who also requested this change, and address any of the concerns raised?
Sure.
Should be on.
Okay, yeah, so the goal was for a limited driving permit to allow, in the circumstances where somebody was in an accountability court, as a measuring stick, the carrot and stick, the judges in accountability courts have a limited driving permit. Also, in somebody that has a non-alcohol DUI, that they would have a limited driving permit. If they were getting an alcohol DUI, they should have an ignition interlock, or the fee should be waived so that the poor person can drive under the same conditions as you state.
Or graduated.
All right. So we're actually really getting to an important issue here. So I'd like to get PAC and Gachtel's positions on this if possible. Is it your position that for a DUI alcohol offense, there should not be a limited driving permit issued unless there is an interlock with a reduced fee amount in a hardship indigency circumstance? Is that your position, General Bettis?
Yes, sir, because if you look at the ignition interlock as a therapeutic tool, then you want it to be able to help everyone across the board.
All right, very good. And Ms. Travis, with the understanding the policy spirit of this bill, so would Gachtel's position be that you would prefer that you're not requesting for a DUI alcohol there to be the ability of the court to just issue a limited driving permit as a judge currently can?
Mostly, I think that every tool in the toolbox available to the judge should remain in place.
Okay.
But I agree with Chairman Setzler that's a problem to let disparate people drive differently. One of the difficulties, however, is the way this is set up in terms of measuring indigency doesn't comport with the rest of the code.
Ms. Doldy's here, and I really appreciate you coming on short notice. Thank you. Would you please confirm if I'm correct in this, that a judge, under Senate Bill 208 as it's before us here, a judge could issue a limited driving permit in a DUI alcohol case?
Yes.
Because we're giving just broad discretion to the court to do that.
Get the line number for you so everyone can see it. I believe it's in. So regular limited driving permit.
If you would just pull up your mic as well, please.
Yeah, so line 218 to 219. So if you're subject to more than one suspension for a limited driving permit may be issued, department shall not issue a permit unless authorized by this code section, except upon order of the court issued pursuant to 40-5-76. And those are the accountability courts. And then we've also added in on lines on lines 530, notwithstanding code section 564 to the contrary, issue a defendant a limited driving permit with whatever conditions the court determines. So that would be accountability courts, but then also we added in line 555, which would be just the court that issues the hands down the conviction. Could also issue a limited driving permit there.
So Representative Setzler, if you're seeking an amendment, I think that's the area you'll want to focus. All right, any further conversation about that right now, or can we keep rolling through the bill? All right, so Ms. Doldy, if you wouldn't mind just taking us from section 3 going forward in the bill to give just a brief overview of what we're looking at.
Sure. Okay, so Section 3 was dealing with the limited driving permit eligibility. Section 4 talks about ignition interlock device availability. And again, this would be available to a person that was granted a discharge. And I apologize, I was in a meeting with someone from here, so I didn't catch the first half. I don't know how much you've talked about the conditional discharge. It is at the end of the bill.
We'll take it. We haven't really discussed it yet, so we'll take it in the order that you want.
Okay. So basically, if you get the conditional discharge, and I'll speak to that, what is required for that, you would be eligible for, if that judge that's granting that wants to give you an IID permit, he or she could do that, as well as if you're actually convicted of a first DUI, you would be eligible there. And so that's just on lines 336 to 343. And then 370, the new language in 372 to 378 into 381 talks about what you have to show DDS, and that's again to coincide with this idea that a court is going to, the different courts that would be involved now in submitting paperwork. 404 through 426 was in the last version of the bill, but it was discussed earlier. We are removing the conditions upon which you can, or when you can use this IID permit. So you would be eligible to drive immediately upon getting it to wherever you want, versus now there are limited instances in places you can drive on an ignition interlock device. Lines 431 to 435 sort of clears up a little bit of an issue that if you get charged, if you get convicted of the underlying DUI, you're not going to lose your IID permit, because I think right now that is sort of a loophole that's happening, that if you get, it's for the same offense, they can now take your IID permit away when
So
you've got it as a pre-conviction.
It's an administrative suspension that's avoided through use of an IID currently. So you're driving on that limited permit, then you say plead guilty to the underlying offense, and by operation of law, it might it does cause a resuspension, and this would prevent the interruption. Is that fair?
Correct, yes.
All right.
So that's pretty
You're on.
much
You're on.
section
Go ahead.
4.
And Ms. Doldie, question. I'm trying to understand these code section references. If someone is busted for speeding, doing 21 miles an hour to the speed limit, not reckless, but 20 over, with an interlock device on their car, do they automatically lose their interlock device? Is it only for DUI?
Yeah, let me look real quick. Where was that language we just were speaking of? Any state law regarding the movement of vehicles, however, yes. So, yes, if you're speeding, you can take it. They can
That
just
was my concern. If it's a shall revoke, my concern is there's no discretion. It's just, you get busted speeding, you get pulled over, driving, 70.
Why don't you circle that, Representative, and that can maybe be another amendment if you want to discuss that.
Mr. Chairman.
Thank you.
All right, so back to section 5, which is line 478 and beyond. This is basically counting any time that you're on an ignition interlock device towards any suspension afterwards, post-conviction and pre-conviction. Like section 6 of the bill, it's just basically cleanup, designating, there's a certain article that's, I think with criminal justice reform and some changes over the few years, it's the DUI drugs and drug offenses were separated out, but there's no cross references to this anymore, so it's essentially cleanup. Section 7 of the bill is new. It's pulling in the concept of granting a limited driving permit to a first DUI drugs conviction. And so, as we did it in the section allowing for eligibility, we added that in. We're also removing from this code section the part that says they're ineligible. So there was that bill that's gone through and
House Bill 799.
trying
Yep.
to make sure it's what we're wanting to do there. Section 8 is all of, again, I referred to this earlier about what the different judges of these courts can do. We're not touching what the drug courts, mental health courts, veteran courts, and DUI courts can do as part of their, what do we call it? The reward or sanction for behavior. The only thing we're changing is that now we're saying they can issue a limited driving permit regardless of what we're saying in the eligibility requirements for limited driving permit code section. And then we're not making it a year, because this is going to be depending on which conviction or which offense it was. It could be longer than a year, it could be less policy-wise if that number changes quickly in this bill. And then on 548 on, we're talking about a judge that hands down the conviction for a first DUI alcohol. They can also issue an ignition interlock device driving permit. They can suspend or revoke it, and they can also issue that limited driving permit as long as they've been a finding of undue financial hardship, which we will get to a little bit later in the bill. And they would have to pay the fee and all that. So section 9 is cleanup. Section 10 is we're changing the definition of a major traffic violation for purposes of dealing with commercial driver's licenses. And so you'll see on line 601 to 602, we're trying to say that if you were granted a dismissal or discharge for your first alcohol-related violation, that it will be treated as a conviction. So trying to protect those federal dollars that are related to commercial driver's licenses, because the federal government is very concerned about how we look at those. And so if we're not hiding it by saying DDS can say that those are actual convictions, the hope is that that would be not seen as masking, which is the federal term for sort of hiding these DUIs.
So, Ms. Doherty, we'll skip section 11. We're going to have a witness about that, and we'll
Okay.
come back to it when the witness has testified.
Okay, and so section 12 is 40-6-391, and this is the conviction portion of DUIs. So for the first, we're again counting these dismissals for purposes, just like we would a NOLO or we would a previous conviction. Imprisonment on line 660 is 24 hours to 12 months, so we changed that. That's was in the previous version of the bill. Again, this would now be a change that the probationer is, or the person that's been convicted is asking for ignition interlocks as form as their probation. It's not considered a part of the punishment like a fine or anything else. So it's maybe would help this issue of indigency and undue financial hardship, because someone would have to actually actively ask for it instead of being forced upon them. So this, throughout this whole code section, that's pretty much what we're doing, because we need to make sure that the discharges and dismissals are being counted for purposes of futures. So throughout this, for the second we do that, and we do again the same concept that they're asking for an ignition interlock if they want to drive during any time of suspension. So that's on page 20, 21, 22. And then section 13 is the, we're placing a cap on the amount that an ignition interlock device provider can charge for various things. And you'll see those on line 802 through 805.
It's my understanding we're codifying an existing regulation here.
Yes,
Is that correct?
I'm not sure about the lockout fee. The provider, if the providers are here, I'm sure they could speak to that.
Okay.
But yes, that should mirror what DDS regulations are on these industries. And then 809 through 813 talks about the concept that a court can issue a waiver of certain fees, and if they find indigency at the time of conviction, they can say someone is indigent, and we'll go through the different factors for determining that in a bit. But if the provider sender is basically going to agree to, in exchange for showing this waiver, they're going to give a reduced monthly rate of half the standard charge, and then no cost installation. Section 14 of the bill is all just dealing with if you get granted a conditional discharge or dismissal, the court may issue an ignition interlock device permit. So it really matches what we're doing on the second currently. And again, except for someone has to actively ask for, I want to drive, so I need this permit, please give it to me. So that's really all talking about the powers of the court regarding conditional discharges in that section. And it really does mirror very closely to what we're doing in the next code section, starting on line 860 for the first. And you have to have it on any vehicle you plan to drive. So you'll have installed and maintained in each vehicle registered in such person's name. I'm looking at 867 right now. And any other motor vehicle to be driven by such person a certificate or certified ignition interlock device, and you're not allowed to drive without it. So that is, again, we're doing that in the second. as well. Some cleanup there. The big change would be starting on lines 9-12. So here we're talking about this concept of undue financial hardship. So we're going to have undue financial hardship, which is what we currently have, which would allow a judge to say, you don't have to do any of this stuff. I'm going to issue this limited driving permit. And instead of just letting a judge have total discretion on that, we're giving some guidelines of what the probationer should be showing to the court. And you'll see it's federal income tax return that shows income or household income does not exceed 125% of federal poverty level, most recent wages, and you'll see all this new language is, showing to the court why you would qualify for an undue financial hardship condition. Then we're also adding in that you could also have a fee waiver instead of that. So on lines 936, the court can issue a waiver of fees assessed by the IID provider for the amount set forth in 2D of 110, which is basically going to be the half off monthly fee and a free install. So and then for determining whether they will waive the fees or fines, you're going to look at code section 42.8.102 for those guidelines. And that's a little broader of a...
Mr. Chair, can I?
Yeah, certainly. What's your number?
Oh, I'm sorry, Mr. Chair. It's 9.
Very good. Yes, sir. Representative Bodie.
So thank you so much, Mr. Chair. I do have one question because my day job, I practice criminal defense. Line 9, 21, and 22, where we're talking about the federal income tax returns. Now, do we do this anywhere else in the criminal code? I'm just kind of leery of having federal income tax returns and judges handling that and prosecutors and defense attorneys, because I don't know anywhere in the code that we do that. Even with indigent defense
Right.
cases and qualifying for the Public Defender Standards Council.
I might defer to maybe Gactyl on that of knowing whether we do federal tax returns. I'm unaware of it.
I'm unaware.
It just makes me look uncomfortable, respectfully.
All right, so I would I appreciate you catching that as we go, Representative, and maybe you'll circle that
Yes.
line number, and we'll come back to that if you want to discuss it in the
Thank you.
amendments portion.
Okay.
All right.
Mr. Chair.
Yeah.
Perhaps, they would have to demonstrate this. Tax records might be a means of doing it. We just say they've got to demonstrate that they're.
We'll
a certain
hold on
income
that
level.
for right now if it's all right with the committee, and let's keep running through, and then we'll have discussions on each of these later. All right, Ms.
Okay.
Doldy.
So we discussed they're going to be the undue financial hardship or a waiver could be issued by the court, or fee waiver. Section 16 of the bill, we're just sort of cleaning up, again, applicable period of suspension throughout instead of 1 year. Again, it currently is 1 year, but I think at some point there was different numbers involved, so it would just be easier going forward to track it. Excuse me, track it instead of saying it's a year going forward. Section 17 is, again, cleanup of cross-referencing, and talks about how it would be revoked. The same with 18 is you can't have someone else take the test or blow into the device for you. And I think, if we'll make a note, I think those two sections need to add in references to the new language in, sorry, I'm just seeing this, the new codes, the conditional discharge ordered ones on 42.8.110.2. So if we could just add that in to both 16 and 17 where it says A and B, we'll need a cross-reference there. Sorry, I didn't catch that earlier. And then in section 19, we're talking about the conditional discharge. So in order to qualify for the conditional discharge, it would have to be an alcohol-related violation of 391, and you'd also have had to submitted to the test and blown less, and your alcohol concentration should have been less than 0.15. If you're over that, you don't qualify for the conditional discharge. So that's a little different than, and again, this is in lieu of the pretrial diversion that was discussed in the last version. It's we're going to do conditional discharge instead. You'll see on lines 1048 through 1053, basically saying here that the conditional discharge will be used to disqualify you for counting purposes for suspensions and for commercial driver's licenses. And then it's also not going to be record restricted. You'll see on line 1052 to 1053, except for a discharge or dismissal for alcohol-related violation of Code Section 40-69331. They will not, your employers could see this. And again, access to the criminal history will not be restricted, and you cannot qualify for this if you are a commercial driver holder at the time. And that's again for federal dollars concerns there. Section 20 of the bill, we start talking about the changes that needed to happen for the ignition interlock device providers. So we're changing the provider center definition. That's a little bit of cleanup considering they currently do. That probably should have been in years ago because we do have limited driving permits, ignition interlock limited driving permits that are being issued currently. Section 21 is saying that a provider center, in order to operate, would be and be granted a license by DDS, that they have to agree to the half-off monthly fee and free install upon the court order if they determine indigency. Section 22 is basically saying that the operators, ignition interlock providers, could have their license suspended or revoked if they have engaged in a pattern of refusing to install the service with a court order. So if they're consistently not following court orders to go ahead and install for free or reduce services, they can have their license revoked.
All right, Representative Reeves.
Thank you, Mr. Chairman, and that's exactly what my question is on what we just finished up with. Maybe I missed something. Is there in order to be a provider to install these things, is there an agreement on the front end that they have to make that says that they will comply with these court orders to reduce fees and install for free? Is that an agreement that the manufacturer or whoever it is that installs these devices, do they make that agreement on the front end, and is that one of the conditions that allows them to engage in this business?
So I think DDS currently is certifying them because they are providing these limited driving permits, and that would require an agreement as to the regulations is my assumption. I don't know that, but Ms. Doherty, do you have anything to add?
Yeah, the 4312A, there's several code sections that talk about how you can get licensed as a provider. And so in 20 and 21, we're saying in order to be licensed, you're now going to have to agree to honor the court order. And if you don't, if we see you're consistently not doing it, because, this isn't one provider, it's a driver can go to any local provider they want to. So you don't want the driver to have to consistently keep hopping around because no one's honoring the waiver or the court order.
Okay. All right. That makes sense to me.
All right. So what I'll do is I will ask, Hanif, would you please step out? Ask Cash if he would come in and testify. All right, so at Section 11, I'd heard from an advocate that was interested in addressing an issue currently requiring for the cameras in school zones. There is a requirement of certification from the Department of Transportation, which has been problematic for some of our cities, specifically I believe some cities in the metro Atlanta area, in achieving this, which the law would otherwise permit. And so Section 11 of this bill is to address that by removing part of the code. There's no addition that's in Section 11. It's just removing that requirement. You all can read it if to review that. All right, very good. Any questions for Ms. Doldy? Representative McLaurin.
Thank you, Mr. Chair, and thanks again for all your hard work on this, Ms. Doldy. I just noticed for the first time the lack of record restriction for alcohol-related conditional discharges. What then, if that's not going to be in effect, would be the difference between a conditional discharge and a conviction? I'm not sure what the conditional discharge would accomplish at that point if there's no record restriction.
I would assume just allowing the court to impose whatever sentence they feel versus the codified in 391, which is, has.
Not a criminal conviction.
Right.
So it's not a conviction and there's some sentencing discretion, is that the idea?
Yeah, I believe so.
Okay.
And Mr. Chairman, if I may, I mean, the benefit is that, have you ever been convicted of driving under the influence of alcohol? The answer would be no. Even though there's no restriction, there's a tremendous benefit to that, and this is sweeping change right here. And I mean, we've been talking about this for a long time. And you can technically shoot somebody and get first offender, right? But under current DUI laws, you can't get to that place of no conviction. This is a very sweeping change that, and so, but the importance from a public policy standpoint, and I say this just with the benefit of my career, with the importance of keeping our streets safe from those who drive under the influence, and also knowing the tendency of repeat offenders, then if somebody should receive that benefit, it's very important, if they should ever be in the situation again where they're charged, that the state be aware that this isn't their first experience with this.
Representative McLaurin.
So thanks, Mr. Chair, and thanks, Chairman Reese, for elucidating that. My understanding, though, is that the way this bill works is that even with the CD option, for recidivist purposes, the CD is recognized as a prior conviction. So I don't know that that's a concern in the bill. I guess my thought is, since you're right that DUI law doesn't allow that first bite, if you have a job application that asks that question, it's going to say conviction. I don't see why, absent record restriction, that question wouldn't just change in every relevant context to.
Have you ever been arrested?
Have you ever been arrested, or have you previously received some sort of final disposition, that was not guilty regarding, or whatever the question would have to read. And
perhaps you're right, but I think we have to weigh balancing these public policy options, and we might be 9/10 of the way there, but 9/10 is a whole lot better than 3/10, right?
Well, and to your point about recidivism, my understanding, the stat we've been working with, is that roughly 2/3 of first-time offenders do not reoffend.
Yeah, and a lot of people die from the 1/3 that do.
Understood, sir, and I think that's why we have criminal justice response to that 2/3 of folks, regardless, and there are real consequences, which I think this 30-page bill is about. But
so while we're talking about records restriction, if I may interrupt, is Ms. Salim, would you see if there's anyone from DDS in the hall? I just got a text that they might want to provide some additional input here. No. Mm-mm. Yeah. No. So, the text, I've just received a long text, but it's my understanding that as long as CDLs are not covered in the conditional discharge, it's not considered masking. I'll just reply back and see if anyone wants to come and testify. So, General Bettis, go ahead.
Well, as I understand a conditional discharge, there's no conviction there to restrict. That's the good thing about it. Record restriction would be something that you would apply when there's an actual conviction. And we have a retroactive first offender now for various charges. I've even used it when there was a family violence case and the person had never been arrested, didn't have an attorney, and pled guilty to a simple battery. They can go back and retroactively get first offender. And the luxury of a conditional discharge is there's nothing there to restrict. So
I'm sorry, you and I will disagree on that. You're restricting the arrest in a typical circumstance, and so that will not be available here, just to make that clear. Representative Montana.
Mr. Chairman, I've got a few notes here, but I do want to talk to this point. And could Jenna give us a better understanding of what those requirements for that conditional discharge? Is it just this IID? Is that it, or are we leaving it to the judge? What are the actual requirements?
So it would be judicial discretion at that point. They would.
So the previous draft of the bill had certain minimum conditions which must be included in any diversion program, and those are not included here.
Mr. Chairman, if I may, I would ask that we have some minimum requirements. You know, as far as the state goes, I feel like we have the responsibility to make sure that.
So in the previous draft of the bill, the minimum requirements were 72 hours in jail, 100 hours community service, alcohol risk reduction, drug and alcohol evaluation, and the IID. And so you can just maybe make some notes, and if you'd like to propose an amendment at the appropriate time, I'll recognize you for that.
Thank you, sir.
Any other questions? Yes, Representative Burchett.
Sorry, Cash is out there. I didn't know if you still wanted him to testify.
Yeah, could we ask him to come in, please? So would you come forward, please, Cash, and I'll recognize you here at the witness mic to just speak to Section 11 of the bill.
And I don't have it in front of me.
Here we go. There haven't been any questions about it, but thus far, but just to explain the need or the need for the request.
Yes, sir. Cash Trevetti here on behalf of the city of Smyrna, also a resident of the city as well. It's my understanding that the local government there wanted these cameras in place. However, the school district, who's the ultimate applicant, kind of held up that process. So we feel that Section 11 would make it easier to have these cameras installed in school zones.
All right. Any questions for the witness? Yes, Representative Setzler.
I'll try my best, Mr. Chairman.
If I could, look, I want to explore Section 11. I was not aware of a cameras in school zones component to this. Forgive me for that, Mr. Chairman. Could we delve into that in some detail? What's contemplated here?
So it's my understanding the application process begins and ends with the school district. So the city of Smyrna would like for these cameras to be installed, but the school district haven't applied for them.
Mr. Chairman,
I think there's a requirement that they secure a permit from the Department of Transportation under existing law, and this would remove that requirement.
Yes, sir.
Mr. Chairman, I was part of this debate about cameras was the second largest school district in the state, Cobb County Schools, has said, we will not do this. My superintendent looked me in the face and says, we will not do this. He finds it pernicious. I think the idea of...
Representative, I know you're passionate about this issue. Would it be all right if we suspend for until discussion? If you have any questions for Mr. Trevetti, you can ask those. Okay.
I can come meet with you, Mr. Chairman.
And I'll certainly recognize you at the appropriate time. I don't want you to think I'm cutting you off.
The only point I was making, Mr. Chairman, is part of the balance here is school districts have influence over that, and I wouldn't want to take that influence away.
Yes, sir. All right. All right. Any other questions for the witness? Thank you very much.
Mr. Chairman.
All right. So we're now back to the bill. I am interested in any final comments, if it's all right, from from PAC. Just any final comments you want to give, General Bettis, on the bill?
I do. I have some questions about section 15, where it talks about a first and 5 and a second and 5, and it refers to 40-5-63, which is a 120-day waiting period before they can get any type of permit. Just want to make sure I'm understanding that that's back in the bill, that a person does have to have experience sometime without a license before they can get an ignition interlock, particularly for a second and 5 DUI. So on page 25, section 15.
All right, so we're gonna look at 63 and what we did there.
We'll give Ms. Doldie a minute to look for that, but you're just asking about the hard 4-month suspension on a second.
Right.
Is that correct?
There's an
Yeah.
actual time period where they're without a license.
Understood.
Oh,
Yes.
on the second, yes, we don't touch the second. And
That is
this bill.
unchanged in this draft. Good question. Thank you. All right. Any other questions, General Bettis?
If I could just refer back.
Sure.
I thought 40-5-63 also touched on first and 5 DUI.
It does touch on first and 5.
So that there's also a 120-day waiting period. And I thought the first bill allowed a person on a first, well, and a second. We were opposed to the part on the second DUI, but it allowed a person with a first to go and get their ignition interlock permit day of conviction. So
Yeah, that's not
is that-
changed.
okay.
That is unchanged.
Okay, thank you.
Yeah, that you're correct. Thank you. All right, Ms. Travis.
Actually, I think to the general's point, it is changed. I will try and find the line number.
Okay.
For that. I agree with the general on that concern.
Well, I'm not sure I understand then. So are you saying that you should not be able to get your limited driving permit, your IID permit, on a first DUI the day of the conviction?
I'm talking about the second.
Okay.
as the
Yeah, I'm
general
sorry,
is.
you're right. I didn't get to that page, if you're correct. Because currently the waiting period is, where is that? You might know off the top of your head faster than I do.
I'm trying to find it.
120-day waiting period.
That's on a first. On a second, the waiting period. It was 120 days as well. Yep, so that is removed. Sorry. I misspoke.
So they do have to wait, or they don't?
They do not have to wait.
On a
So it,
first.
on a first and second.
And that's
All right.
what concern-
So
Yep.
we would like to, so General, you wanted to restore the 4-month hard suspension on a second DUI. All right, because that is, thank you for pointing that out. That is not in this current draft. And maybe a member up here wants to make a note if a member wants to propose that amendment. Ms. Travis joined in the concern on that, I thought. Or I won't speak for you. What issue did you raise, Ms. Travis?
I was just agreeing with the general.
Okay, very good.
Specifically, basically the entire point of a conditional discharge is for record restriction. And specifically, I'll direct your attention to lines 1053 to 1054 that says that you are disqualified from employment if you have a DUI and you get a conditional discharge. The whole point of a conditional discharge is that you can actually put something behind you. A DUI is not eligible for first offender, so the analogy to first offender doesn't really come into play. But to the point of Chairman Reeves saying that how wonderful a conditional discharge could be to people's future in employment, they have to reveal it. It says that any information, including the fingerprints taken with the arrest, shall not be restricted. So you're going to have to
So I'm
reveal.
sorry to interrupt you, but both PAC and GACTL preferred a conditional discharge as opposed to the diversion that was proposed before. And we've all heard that prohibiting restriction is necessary in order to not interrupt state of Georgia's federal funds.
No, sir, that's not correct.
Okay.
It's only with regard to CDLs. with CDL money, having a commercial driver's license. It's my understanding when we talked to DDS specifically about this, and there was no such concern about record restriction.
So the prohibition on records restriction then would only be to drivers with CDLs.
Correct.
Or rather, it would be prohibiting conditional discharge for drivers with CDLs.
Correct.
Okay.
And the way that Representative McLaurin had presented it was you couldn't get a conditional discharge if you were a CDL driver, and even if you wanted to get a CDL driver's license in the future. So say you're 25, you're convicted of driving under the influence, you want to use your conditional discharge, and then at age 30 you want to become a CDL driver, it's too bad. You're not going to be eligible, and that's the way it was drafted. But there's no way that GACTL can support this bill with taking record restriction out, because conditional discharge would become meaningless. And then the other thing that I would raise as well is the way the financial thing is set up. Indigency in 428102 is tied to 100% of the guidelines as opposed to 125% of federal guidelines. So it made it even harder
It's
to
a
get
different standard.
a different standard.
Understood.
Yes, sir.
All right. So thank you very much, PAC and GACTL, for providing input. We'll now hear from members of the committee. I see Representative Momptan. First, I'll call on Vice Chairman Reeves.
And thank you, Mr. Chairman. And as a comment to Ms. Travis's point just now, I understand that as conditional discharge currently exists in the law, that it's tied to a record restriction component. But I see no obstruction or barrier to changing that law to say that that record restriction would still apply to every conditional discharge conviction except for 4-6-391, which is what line 1058 says. Again, just because currently all of the current offenses that you could be convicted for under that code section allow you that benefit does not mean that in perpetuity everything that we seek to put under the umbrella of this beneficial program has to also include record restriction. And I mean, this feels like cutting off our nose to spite our face. I'm surprised that GACTL is not in support of this because of that, because I just feel like this is truly offering a benefit that's never been out there, so I'm confused, and I don't understand why there's not a better acceptance of this from GACTL. And if there's an explanation, I'd love to hear it.
All right, Representative Momptan.
Thank you, Mr. Chairman, if y'all can hear me. So I just wanted to talk to that. I've got a number of different questions for the bill.
Which number are you?
This is mic number 5.
Okay.
All right. Can y'all hear me?
Yes.
Okay. So, a state action that prevents a CLP or CDL holder's conviction from appearing on the CDLIS driver record is considered masking. And so when we talk about masking, it's kind of the operability of both past and future, right? So if you have somebody who's not currently a CDL license holder but could become one in the future, that information does have to be available to not be considered. It's my understanding that that information would have to be considered. So to DDS's point, they do have to have some sort of record, either GCIS or another database to track that, so we don't lose those federal dollars. Obviously, with the budget constraints that we have, we just can't risk those federal dollars right now coming from the federal motor vehicle carrier. So if it's the appropriate time, I'd like to ask some questions, maybe to Jenna if she's still here, or.
It's my opinion that it's appropriate time to consider a motion if any member of the committee wants to make one. Recognize Representative Burchett.
I'd like to make a motion to pass.
All right, there's a motion to pass on Senate Bill 208, the committee substitute, Senate Bill 208 LC 392707S. Is there a second? Second. All right, there's a motion and a second. All right, the bill is now before the committee. So at this point in time, I'm happy we can really do what you want. I know we've got everybody has a busy day today. So maybe rather than discussion, we maybe consider amendments, or if you'd prefer to have some discussion, we can get there. What maybe I'd prefer is let's just get into the policy questions through amendments here, and we can just identify what's needs to be decided before the committee. So, Representative Momptan.
Okay, so Mr. Chairman, I'm actually going off an old one where I took my notes, which is the 2666. So
okay,
I have a new one, and if you will help me find, we struck the provision, I believe it's in section 5.
You want me to come back to you so that you can update your notes to the current draft? Would that be?
There's a lot of them. It would take me a substantial amount of time if we could.
Right.
And this is related to the locations in which a person who holds a limited driver's permit can drive to and from. So this was I believe it was like to and from church or place of work or whatever it may be. Let me find that real quick, Mr. Chairman. Is it 404 now?
Yes.
Okay. Had to be close. So 404. So, Mr. Chairman, I would make a motion to amend the bill to include the information from 404 through 426.
So to leave that in the code.
Leave that in the code. Yes, Mr. Chairman.
All right. Is there a second? Second. All right. There's a motion and a second. Any discussion about the Momptan amendment?
I don't understand it, Mr. Chairman. What's it do?
So, Mr. Chairman, if I may explain the reason for it. These are folks, we know statistically that a first offender has offended on average 80 times before they're caught for the first DUI. That's a NHTSA statistic. This would basically recognize that and say, hey, look, we understand that you're a risk. And while, yes, we want to make sure that you're getting back on the road and do the things that you need to for gainful employment or for the operation of your household, we also don't recognize the fact that we want you to drive to Six Flags, right?
So,
It's drive anywhere versus drive restricted places.
That's right.
So, if you don't mind, I'll interrupt you. Ms. Doldie, will the amendment as described, will it have the purpose sought of restricting the places where the person can drive?
Yeah, it would just revert to current law that you can only drive in these specific places with an IID permit.
All right, very good. Any other, now that I think we all understand what it will do, any other discussion? Representative McLaurin.
Thanks, Mr. Chair. My understanding is this wouldn't cover grocery stores. It would not cover places to exercise. My understanding is there are aspects of basic quality of life that this language doesn't cover, which is why the committee was inclined to move away from this model.
Okay. I think everybody understands the policy decision here then before the committee. So on the Momptan First Amendment, there's been a motion, a second. Any other discussion? All right. All those in favor signify by raising your hand. 4, 5, 6, 6. All opposed? 1, 2, 3, 4. All right. The amendment passes 6-4.
Mr. Chairman,
All right.
if I
Yes,
may
sir.
continue.
Please go ahead.
Line 586 to 587, and this may actually go in with the conditional discharge language that we were looking at earlier. I asked the question, what are the requirements of the conditional discharge? And I'm just asking to amend the conditional discharge language to include the minimum requirements from before. And now the 586 was the old number. Ms. Dolden may be able to help us find that in the new.
Can you tell me the code section
Yeah, sure
you're
thing.
referencing? 40-576.
That sounds right to me.
What is it? It would be section 8, I believe.
Yeah, that was
Okay,
under
so-
40-6-391, and basically this is where the old language was the pretrial intervention and diversion program. We had excluded some of those minimum requirements there, and I think we moved over to this new model of conditional discharge. And I think to sum up the amendment, it would be that for any conditional discharge, we meet those minimum requirements that you see, on your first, second, third DUIs. That could be anything from attending a risk reduction course to clinical evaluation. And
Do you mind if I help you a little bit with this?
Yes, sir.
Would it
Be wonderful.
Would it be for your first? The minimum would be for your first, or for the greatest of any of the first, second, or third?
Yes, sir. So I would say, starting with your first, you'd have to meet those minimum guidelines as were in code before.
All right, so as I understand the Momptan Amendment 2, it's for use of conditional discharge. Under the circumstances here, there'd be a minimum of 24 hours in jail, 12 months probation, 40 hours community service, the fine provision, DUI risk reduction, and alcohol and drug evaluation. Is that correct, Ms. Doldy?
So you want to mirror the first offense conviction stuff for 391, or you want to mirror what we did with the pretrial in the last version of the bill?
No, he wants to, as I understand it, he wants to put first conviction minimum conditions on a 1613-2.
Okay, I would put that in section 19 and not.
Okay.
Is that what you want to do?
Yeah. That's
Not the more harsh conditions that we had for pretrial diversion last version of this bill.
That's right. I would
Okay.
say just make sure that we're tracking it through the multiple offenders as we get into the second and third DUIs. Obviously, things
Well,
like
they can't use conditional discharge again.
Okay.
So,
Okay.
yeah.
Well, perfect. So
Mhm.
yeah, just track it to the first one. Yes. Sir.
All right. Is there a second to the Momptan Amendment 2? Second. All right. The motion and second. All those in any further discussion? All those in favor signify by raising your hand. 2, 3, 4, 6, 7. All opposed? 7 to 3, it passes. All right. Ms. Doldy, you got that? Okay. All right. Next amendment.
Mr. Chairman, if I may offer up a amendment, this is going to actually bring up some conversation and discussion on a section. The old section was 730 through 740. The new section deals with how tracked by the Department of Revenue for the vehicles. So I'm going to try to address this via an amendment, but if any members can help me here, it'll be appreciated. But basically, I'd like to add some teeth to how this is tracked, and that would be and it may already be in there, I didn't see it, Ms. Doldy, but basically if somebody operates a vehicle that is not covered or was not turned into the judge under this conditional discharge or IID process, and they're driving another vehicle, or they get a vehicle and they do not inform the courts or the judge, that they would then have to they would lose their ability to have an IID. Does that make sense? So basically, there has to be some teeth to the fact that if you say that you're driving a Toyota Camry, I pull you over and you're now in your uncle's F-150, you lost your privileges. I didn't see that in the bill, but I wanted to address that.
All right. That might be a little difficult to just add in on the fly here. Would you like to maybe chat with Mr. Lanier while we have any other discussion to nail down your language, or do you have the language?
I don't have the language, but I can skip to the next amendment if you'd like to.
Yeah, maybe let's do that, and then we'll come back to.
Okay. The next language that I have is under the provider center. I do have some heartburn. I had received some reports that there were ignition interlock devices being installed in gas stations where a alcohol, liquor, or tobacco product may be sold. Obviously, that could be problematic if you're getting your ignition interlock at a place where you bought your liquor. And so we obviously want to address that here. I think it's appropriate, and we, if I could, no provider center. This would be the amendment, if I may make a motion to make this amendment.
So would this be?
Oh, I'm sorry. This would be under the new section 21. I believe it's 21. I'm sorry, 1060. 1066. I'd do 1069. It would be somewhere. in section
Okay.
20, I'm sorry.
Yeah, section 2020.
1066 to 1069, okay. All right, what's
Yes,
the amendment language?
Okay, and I have a rough draft here. We would place this within the appropriate section. No provider center may be eligible to sell, provide, loan, or install any equipment at any place where alcohol, tobacco, alcohol-related, tobacco-related items are being sold, or adjacent to any place where alcohol, tobacco, alcohol-related, or tobacco-related products may be sold.
Mr. Chairman, I don't know if this, do you want a distance? I mean, thinking, you want a distance requirement? Because again, you got a strip shopping center, and I mean, you could segment this thing out. You can have you can have a separate company that owns
All right.
it.
All right.
You can get around this pretty easy unless you're pretty slick.
All right, so there's an amendment. Is there this is the Momptan Amendment 4. Is there a second?
Second.
There's a motion is second. The third we table. We'll come back to it. All right, so now there's discussion concerning the proximity. Representative McLaurin.
Thank you, Mr. Chair. I don't see any way in which the proximity would change the operation of an IID device. It kind of feels like as a committee we're crossing a threshold and do a more sort of puritanical beating up on the concept of DUI. And I don't know that type of moralizing is helpful for our policy discussions. I think this amendment reflects that perspective.
Well, I appreciate that. We'll just treat we'll treat all ideas with respect right now and let the committee process work. Just trust the process. So any other members who have discussion about the Momptahan Amendment? Representative Setzler.
Mr. Chairman, I don't think I'm friendly to the amendment, but I want to help you with your amendment.
Sure.
Just so it accomplishes. I mean, to me, I'd put if you think about like a truck stop or something like that, you've got a Popeyes fried chicken, you've got a convenience store, you've got a restaurant, all kind of things. I mean, I would put a distance requirement within 1,000 feet, or you're not going to be able to get this. It's not going to do anything for
Sure.
you.
And I'm open to that. Mr. Chairman, all I'm doing with this amendment is actually tracking a rule that's been promulgated by the Georgia Department of Driver Services related to DUI schools. They use that language
So
adjacent
you're comfortable
to,
with your amendment language as is?
However, if the committee feels like that amendment would fail, I am open to changing it to a distance requirement.
Well, we'll just go through the process right now and see what the will of the committee is on it. So, all right, the Momptahan Amendment 4 is before us at this time, and Mr. Meyer's going to sit next to you and write it down if that's all right. Easier to look on. So, thank you. All right. So, any further discussion on Momptahan 4? Seeing none, all those in favor signify by raising your hand.
I'm for it. Yeah.
2.
Mm-hmm.
2. All right. All opposed. 1, 2, 3, 4, 5, 6, 7, 8, 9. Amendment fails. 2 to 9. All right. So we will now move on to. Do you have any other amendments? Sorry. All right. Do you have any other amendments, Representative Momptahan?
Well, I'd like to make an additional amendment to specify that no provider, or I'm sorry, let me make sure I use the right language. No provider center of a ignition interlock device can operate within 1,000 feet of any place where alcohol, tobacco, alcohol-related, tobacco-related products are sold.
All right. The Momptahan Amendment 5 is now before the committee. Is there a second? All right. There's a motion and second. Any further discussion? Seeing none, all those in favor signify by raising their hand. 1, 2, 3, 4. 4. All right. All opposed? 1, 2, 3, 4, 5, 6, 7. Fails. 4 to 7. All right. Do you have any other amendments, Representative Momptahan? All right, let's go back. You don't have any others? Let's go back to your third then that I tabled a minute ago.
Sure.
Say that again for the committee.
All right. So,
I don't think he has a line. He's
yeah, I was using the LC from last week. So the question was, and this was in the old bill, and I'm so sorry again. This was for line 730 through 740 in the old bill. Let me find out what code section that is, or what section that is now. This is in the old section 10.
What's the code site?
That is chapter 8. Let's see, Article 7, chapter 8, title 42.
It starts on line 795. I don't know if you want to put it there, though.
Okay. So what was the amendment?
Well, Mr. Chairman, this was a amendment that I had that I was just begging the question of basically putting some teeth on the, if a person operates a vehicle who has been given a temporary driving privilege to, if they are caught finding, or if they're caught driving another vehicle during that period of time, so if it's a 12-month suspension with an IID, that then they would lose that privilege, and it would go back to a hard suspension.
Okay, so if the person operating a vehicle in which an IID has not been installed is caught, then they restart
Yes, sir.
the period. Is that fair?
Yes, Mr. Chairman, that's correct.
All right. Is there a second? All right, there's a motion. Is there a second? Montan 3. There's a motion and second. Any further discussion? Hearing none. All those in favor, raise your hand. 2. All opposed? All right, it fails. Okay. All right. Any other members? Yes, Representative Setzler.
Amendments, Mr. Chairman, if we could. We'll try to get through these here with efficiency. Forgive me while I go through, make sure I get every one of these. These have been talked about already in the committee hearing. The first one is going to be on page 13, I believe. Yes, sir. It's page 13, lines 428 through 437. And the underlying issue it addresses is the issue of revocation of an interlocked limited driving permit for other offenses. Again, 428 through 437. 428 through 437. Mr. Chairman, what I would, before I state the amendment, the underlying policy goal is that it's at the discretion of the court that if you have any other offense that you lose your interlock limited driving permit. For example, if you get popped for doing 52 and a 35 or 72 and a 55. As it's stated in the existing bill, you would, any offense, any traffic offense, you're going to lose your interlock device and you can't drive. To me, I believe that a court should have the discretion. If it's a simple moving violation, if it's a failure to stop at a stop sign, you roll a stop sign in your neighborhood, you automatic. So
what's the amendment?
Amendment would be, I would add on line 428 at the beginning of this subparagraph, upon order of the court, comma, the department shall revoke.
Upon order of the court, comma,
yes, sir,
is the amendment.
And then there's another piece to make this correct.
Okay.
Down below on line 435. It would read, any court in which such conviction is had, that requires, so it's striking shall, it would be that require, and put an S on require, that requires. It would read down and then strike the court shall forward the device to the department. So it would read, any court in which such, again on line 435 through 438, any court in which such conviction is had, that requires such permittee to surrender the ignition interlock device limited driving permit to the court, shall forward the device to the department within 10 days of conviction. So it just cleans up that language below, but really the essence of it is upon order of the court, comma, at the beginning on line 428.
All right, everyone understand the amendment? All right, is there a second?
Second.
Motion and second. All those in favor signify by raising your hand. 2, 3, 4, 5, 6, 7, 8. Okay, all opposed. All right, it passes.
Okay, Mr. Chairman, if I could,
Sure.
on page 16, on lines 555 through 564. This gets to the issue of leaving a limited driving permit as a sort of a parallel track, a parallel option. I think the underlying premise of the bill is that we're moving towards an interlock device for every DUI offense, but that there are provisions in which indigency can be established that could be either half price or no cost. What I'm proposing, Mr. Chairman, is striking lines 555, 56 in its entirety, and then through the circumstances in 557. And then I'm going to state this as an amendment, but it is a question also to Ms. Doldy to make sure this is not wrong, where it says, provided that a finding of undue financial hardship pursuant to Code Section 42-8-111 has been made, I would take that clause and I would insert it at the beginning of line 561. So it would say, provided that a finding of undue financial hardship pursuant to the Code Section has been made, it would read, the court may order the department to issue to the defendant an ignition interlock limited driving permit pursuant to the subsection and so forth.
All right, so I'll restate the amendment. Strike lines 555, 556, and these circumstances on 557, and move provided through made to the beginning of 561.
Yes, sir.
All right, is there a second?
Again, Mr. Chairman, what this does is this idea of a limited driving permit being able to be offered at the pure discretion of the court in parallel to this would go away. So everybody would be under interlock, but there would be opportunity if indigency or low income would make provisions for them to be funded.
Yes, sir. All right, Representative Reeves.
Can you, I'm not following all this very clearly, so can you explain your interpretation of this as it currently stands in this bill versus your amendment?
Okay.
What it does as it's written here versus what your amendment is?
First question, do you understand my policy objective? Because it could be wrong in how I'm offering it.
I'm not sure that I do.
Okay. My policy objective is...
If I may, it's to remove the discretion from the court to continue to give a limited driving permit as it exists right now. That it would either be a financial issue, financial hardship, or a DUI drug that would allow for the limited driving permit. Otherwise, it'd be an IID. Is that fair?
Actually, I believe my goal is DUI drug would be a limited driving permit. The financial issue, you'd still have the interlock device, but you'd have to pay less for it. It'd be half pay.
Yeah, if you can't pay, then you would just have to serve the suspension.
No, sir. The provisions of a lower cost interlock device is accounted for. Everyone gets the interlock device with the DUI offense, but you pay half or you pay none.
Okay. All right. Do you understand the stated
A little bit better than I did.
objective? All right.
Okay.
All right. We need a second on the. Okay. There's a motion, and a second. Any further discussion? All right. Seeing none, all those in favor signify by raising your hands. All in favor of the Setzler Amendment 2, raise your hands.
If the amendment's wrong, Mr. Chairman, I'm not going to even support my amendment. I want to make sure that we're right and we're stepping, that my amendment accomplishes my objective. If I fail to state it properly. then
I haven't taken issue with that, so I'm just interested in votes right now. Are there votes to support the Setzler Amendment 2? 1, 2, 3. All right, all opposed. 1, 2, 3, 4, 5, 6, 7. All right, 7 to 3, or 3 to 7 fails. All right.
Third Setzler amendment, Mr. Chairman?
Yes, sir.
Line 625 through 639, section 11. There's a very careful equilibrium established 2 years ago when we established this issue of photo enforcement of speeding, where people are issued speeding tickets by computers, not by officers. Very careful equilibrium in the policy, and I think section 11 cuts against that equilibrium that was established, that a number of members supported with hesitancy given the equilibrium that was established. I think this tries to move it against that spirit. And I would seek to strike section 11 in its entirety.
Yes, sir. All right, the amendments, third Setzler amendment, strike section 11 in its entirety. Is there a second?
Second.
Motion is second. All those in favor signify by raising your hands. 2, 3, 4. All opposed? 2, 3, 4, 5, 6, 7, 7, 4. All right, amendment fails.
Mr. Chairman, I will postpone consideration of offering another amendment. I've got a
Okay.
language to establish.
Yeah, we'll come back if others have amendments and you find it. All right, any other amendments? Representative Bodie,
Mr. Chair, I just want to make
will you pull your microphone up, please?
Yes, Mr. Chair. I wanted us to, and I want to make sure this wasn't the Setzler Third Amendment, but I do want to pose an amendment to strike lines 921 through line 924. That's what we discussed a little bit earlier in regards to the federal income tax returns. My concern is that we currently don't do this in current practice. I think Section B, 920 lines 925 through 928 kind of gets us to that point where an individual can show a statement of their wages to get us to the same place of trying to show actual income. I just think when we start to have federal income tax returns presented in a court of law, it could get really dicey. And I know the courts are not normally accustomed to doing that. With wage statements, we are. Anytime a client is trying to show that they're indigent and that they need the assistance of the public defenders, they utilize statements. Also, we utilize statements when we are dealing with restitution hearings. So the use of wage statements are something that is common in the court system. However, using federal income tax returns is not. So my amendment today would be to strike lines 921 through 924, Mr. Chair.
I'm sorry, you were saying?
Thank you.
Not just kidding. All right, thank you, Representative Bodie. My light is flashing, so now I'm sitting here. Does anybody have any comments or responses to Representative Bodie's comments about the federal income tax piece? McLaurin, are you 15? Okay, you're live.
Thank you, Mr. Chairman. I think it's a good amendment. I think if we just did away with that one piece, it would still require showing wages, and there would still be verification required. So I think it's a safe move.
Okay. Does anybody else have comments on that? I would like to add my commentary on this. I have an open mind, but I think that when it comes to offer, again, I look at the give and take instead of I try to consider a give and a take instead of a take, the give and take. And I think that when it comes to receiving a benefit that you are going to have to pay, you're going to be required or allowed to pay less, that's a benefit. And I don't have a problem with a court or whoever it may be examining as much the more information the better. It gets us to a better situation. There are people that are very creative, and a lot of this relies on the honor system, right? We in court, sometimes we have to rely on the honor system. We certainly deal with it in child support and alimony situations all the time, and we also know that there is an incredible art to figuring out how to be very creative about that. And so, yeah, if somebody wants to lie about their wages, then that's a risk they take. But I don't have an issue with a court being given access to information that gets us closer to what the truth is. the truth about what somebody's income is. It's just another notch in the belt of truth, which allows a judge to make a better decision or the best decision they can on whether or not somebody should receive this benefit. Who's number 6? Burchett? Setzler.
Mr. Chairman, I mean, would the gentleman accept a sworn statement of their income with this information? Because, I mean, if you have a sworn statement that comes with this, and they lie about it, it's a felony 1 to 5. So it gets the tax records as such out of court, but it does put people on the record. They can't just fudge their income or fail to submit their cash income, which they get on the side, which I think underlies this issue. And that's a concern of mine, that people, hey, here's my job. I made $10,400 last year, but they really made $25,000 because there's a job on the side. Some kind of sworn statement might accomplish the same goal.
Mr. Chair.
What are you, number 9?
Yes, number 9. Mr. Chair, I have no issues with that at all. I think, as you stated before, in the family law aspect, we do verification forms, so I don't mind if you present your wage statements or bank statements that you will have to have a signed verification form along with that. I think that's a great compromise in you not having to present your federal income tax returns. I'm definitely okay with that.
What's the problem with presenting your federal income tax returns?
Because, Mr. Chair, in the criminal aspect, prosecutors are not accustomed to handling federal tax return as well as criminal defense attorneys. Now, in the family law civil context, they are. I know when things are moving, I don't feel comfortable with a prosecutor having individuals' tax returns in their case file. I mean, I'm just going to be honest, and that's no disrespect to anyone, but I think when we can kind of keep that at a minimum, because even with family law attorneys, they look at the documentation, they do the worksheet, but a lot of times they just, if they don't have to, they don't always come to court with the actual federal income tax returns. They use it to complete the domestic worksheet. So I would just kind of caution us, if we don't have to go that route, let's not open the criminal justice form up to tax returns if we have not been doing it in the past.
Mr. Chairman, there could be an issue as well with immigration status of people. People may be kind of off the record or off the rolls from an immigration perspective that wouldn't have tax returns. I don't know if that would influence members. I'm thinking out loud here as among committee members. Maybe that's not relevant. I mean, I'm just trying to get to the heart of the issue and let committee members decide for themselves. But
Burchett.
Thank you, Mr. Chairman. Representative Bodie, what about the state income tax return?
Well, I think we're still in the same posture. I think any tax returns are problematic to me. State income tax return or federal. I just think that what the gentleman stated, the chair stated, I don't mind an amendment to my amendment to add in the verification form, but I think at all costs, when we don't have to have these documents presented in court in a criminal setting, I think we need to err on the side of caution when doing that. And I don't want to open up a Pandora's box here today with this code, where now every new offense, we might be looking at having individuals and defendants come in presenting their tax returns.
Thank you.
So how would you? We're going to vote on your amendment, but I think the only tenable way to do this is to amend to have you alter your amendment. Obviously, you want to strike A, which would then make B in line 925 become A, and there would need to be some kind of language in there that incorporates a sworn statement. So I'm thinking out loud right now. B, a copy of a person's most recent statement of wages, along with a sworn statement verifying that. Well, his amendment problem is that if his amendment passes and then there's an amendment to to add that back in and that fails, then I think we have a problem we're going to have a problem.
From a practical standpoint, to address this issue as the prosecutor,
What's your mic number?
16.
Okay, speak in the mic, please.
From a practical standpoint, from a prosecutor's perspective, we wouldn't see those documents anyway. The undue financial hardship is between the defense attorney and the judge. As a prosecutor, I shouldn't care about that. That's a judge's call if they perceive that this person has financial issues and should either have a free ignition interlock device or a lower reduced installation fee or monthly rate. So I wouldn't never put those documents in my file in any way. That would be a defendant saying, "Sir or ma'am, Your Honor, I have a financial hardship. These are my documents. Can I please get an order from the court that says I get a reduced rate?" I mean, a prosecutor wouldn't object or do anything. That's between the defendant and the judge.
Well, respectfully, but it's nothing in there to say that the prosecutor may or may not ask for those to see them prior to you having this here before the court. I mean, they still, and respect, you may not, but some prosecutor may want to see that and know what's going to be presented during the hearing. Or during the hearing, they can say, okay, if you make that presentation, okay, counsel, can I see the documents before you present them before the court? So I completely understand. I just think that if we don't have to do it, let's just not do it. But I completely understand what you're saying. I respect that.
All right, so here's what I'm going to do. We're gonna call for a vote. Was your amendment to strike A seconded?
No, we didn't get to that point.
All right. Is there a second on Representative Bodie's amendment to strike lines 921 through 924 and then replace B in line 925 with an A? Is there a second to that amendment? Okay. So there is a motion second. Any discussion before we vote? All those in favor of the Bodie amendment, raise your hand. All opposed? Well, actually, I'm not going to vote. 1, 2, 3, 4. All right, it passes. Or, I'm sorry, it fails. Pardon me. Okay, are there any other amendments? Representative Montahan.
Mr. Chairman, I'd like to make an amendment on the encouragement of the Georgia Department of Driver Services, who is currently undergoing some improvements to the drive system. That amendment would make the effective date July 1st, 2021.
What's your number?
Oh, I'm sorry, number 5.
Okay, so he wasn't mic'd, but his amendment is to change on line 1106, section 23, to change the effective date from January 1, 2021 to July 1, 2021. Is there a second?
Second.
Okay, any discussion? All those in favor of the Montahan amendment to change the effective date to July 1st of 2021, raise your hand. All opposed? 1, 2, 3. Okay, let's do that again. All in favor, raise your hand. 1, 2, 3, 4, 5. All opposed? 1, 2, 3, 4, 5, 6. The amendment fails, so this bill will reflect a January 1st compliance date. Number 6.
Mr. Chairman, to the issue of income, this is a question to the general. What is the standard for indigency? Is it previous 3 years' income? Is it income right this minute? Is it last year's? I mean, how do you establish income? If I had an income that was low last year because I was unemployed, but I'm doing fine now, what is the real standard today in our courts?
They normally don't. I mean, the majority of the times that I experience, a person that says I'm indigent when they can't afford an attorney. And so in our court, there's no tax records, there's no check stubs, there's nothing. They fill out an application that they swear to that says that this is my income, monthly income. I have no assets. It has a blank for each section, no assets. This much in my bank account, and they just swear to it. and then the judge reviews that document and determines whether they qualify for a public defender.
Chairman Setzler, what I understand what you're getting at, and if line 925 read, be a copy of a person's statement of wages, comma, covering the prior 12 months, comma, that shows the person's income or household income does not receive 125%, et cetera, then that at least gives a date range where we can see, somebody 6 months ago might have been doing very, very, very well, and then the last month unemployed.
And I'm concerned about household income. I mean, you could have a 22-year-old that lives with others that has no income themselves, but they're taken care of in their household because there's a roof over their head and they would live with parents or relatives that do quite well, and there are resources, that 100% of their income is disposable income. So I just want to make sure that as we're doing this, we're doing it well. I don't want to undo anything, but my concern is really people. Yes, my sense is the courts tend to be sensitive to folks with indigency. I want to make sure the courts are not duped by folks who are kind of faking it and getting free stuff. I think we have an interest in making sure indigent people can be taken care of, and I think we have an interest there. I absolutely believe that. But I also think we need to make sure we draw this tightly enough that you're not able to sidestep the question. So I just, before we move on, I want to make sure this language is as tight as it needs to be.
Do you know, I'm putting on your mic again, do you know in the indigent for qualifying for a public defender, with regarding household income and a person who lives at home, what's the analysis with that as to what Chairman Setzler is saying?
I know it asks for household, but I can't answer that. I just know they ask for that individual's income and assets. So I know you have young adults that may be living at home, but they're the ones that are required to meet, if they're found guilty, meet the probation requirements, not their parents. So I don't know what. I just know it's a form. There is some household questions, but.
Okay, Rep. Burchett, do you have a question? No. Did you want to say anything else? All right, are there any further amendments? I'm sorry, Representative Silcox, did you want to say something?
Given that it's 10 o'clock, I would like to call a question.
Okay. All right, and you know what? I agree. It is 10 o'clock. So we have before us a motion do pass in a second, and we have taken up a plethora of amendments, and all those in favor of the passage of LC 392707S vote by raising your hand, please. 1, 2, 3, 4. All right, so raise your hand if you are for the bill. 1, 2, 3, 4. All those opposed? 1, 2, 3, 4. Okay, there is a 4-4 tie, and I, the chair, am going to vote yes to have this bill pass along. Thank you. This meeting is adjourned.